Welcome to Client School. I'm Brian Godfrey, a legal assistant with Utah Family Law LC, and this is an attorney in our office, Eric Johnson. Today we're going to go over initial disclosures and financial declarations in Utah divorce. So one of the first things I wanted to ask Eric is, what exactly is initial disclosure?
An initial disclosure is something that both of the parties to a divorce action have to exchange with each other to disclose to each other at the beginning of the case, which is why it's called an initial disclosure, of the witnesses and other people that have knowledge that establish your claims and defenses, that help you to make those arguments for the claims and defenses you assert in the case. And both parties have to do that. They have to describe the witnesses by name, address, telephone number, if you know that. If you only know the name and the phone number, then you just put down that the address is unknown. An example of that would be, it was like, well, this is a coworker of mine who has a lot of knowledge about certain things, but I've never been to this person's house. I've never had reason to ask for the address. I mean, if you can just go and ask that person his or her address before, you have an obligation to try to ferret out this information. But if it's somebody who lives someplace else and all you've got is a phone number and you're not that close, then you put down the name, you put down the number. You put down the name, you put down the address, and not the number. So whatever you know. And then you also add a brief description of the subject matter on which this person has knowledge. So it would be something like Jane Doe, and she lives at 123 4th Street, and here's her number, 801, and what have you. And then it would say, this person has been a neighbor of mine for 3 years. Her kids and my kids have played together. I have babysat for Jane. We know each other, and this person can testify as to the kind of parent I am and the kind of character that I have. Then another one would be, this is my boss. My boss can establish that this is how much money I make. That my boss can establish that I don't get a bonus every year like my spouse claims I do. This is the private investigator who I had follow my spouse around to establish the affair, that sort of a thing. The other thing you have to provide in your initial disclosures are any documents or other kinds of evidence, like photographs, recordings, financial records, that sort of a thing. That you could say, well, I need to make a claim for alimony, and here's some 8x10 glossies of the liaisons my spouse was having. I want to establish that I don't make a lot of money, so here are some tax records and pay stubs. It's been alleged that I don't spend a lot of time with the kids, but I've got lots of photographs showing that I go to every school play, and here I am at birthdays, and here we are at home making cookies and stuff like that. Those are things that both parties have to exchange with each other. Those are initial disclosures.
So it's kind of like if we were playing cards, it would be like a preview to the cards that I hold for my
just
case.
a brief glimpse at the cards you hold, because the idea, I think, is to make sure that we understand just what we're dealing with when it comes to the kind of fight that may be looming, and it also helps to establish, like, oh, you know, if what these initial disclosures say is true, I may have a tough time going up against my spouse, or actually, I'm pretty sure my spouse doesn't have a very strong hand, and I can proceed. And it's supposed to help each other kind of analyze the case, figure out how much work they're going to have to do, whether or not this is a fight worth having. So there are other reasons for it too, but I think that's the most important.
Okay. And so what would a financial declaration, I mean, these aren't things that are real glamorous or real exciting and fun. They're oftentimes tedious and boring, but they need to be done. They're super important.
In fact, I can't think of anything at this stage in the case that anybody would find, any client would find glamorous and exciting, and financial declarations would certainly fit into that category. You have to exchange at the same time your initial disclosures and your financial declaration. Now, your financial declaration is a document, it's a form that the court requires you to fill out that identifies your employment status. You have to talk about your income and your sources. You talk about your assets, and that's everything from your real property, if you own a house, or some vacation property or undeveloped land. You talk about the major assets you have, like cars and other things like that. You talk about the bank accounts that you have and the balances in them. You also have to describe your liabilities, your debts and your creditors, how much is owed, what the account numbers are. It's very exhaustive. Let's talk about, you have to disclose what kind of pension and retirement benefits and accounts that you have. And again, you have to be completely forthcoming. This isn't one of those things where it's voluntary. It's not as though, because if you didn't disclose it, it's your spouse's responsibility to call you on it. It's just the opposite. The rules state that if you don't make a disclosure of a particular asset and it's determined that you didn't do that inadvertently, that asset, just by virtue of you not disclosing it, that alone could be a basis. It's not automatic, but it could be a basis for having that asset awarded to your spouse. And again, to use your analogy, It's to show what kind of cards you hold. If you're going to claim, I shouldn't have to pay alimony, but I make $12,000 a month and I don't have a lot of excessive expenses.
You got to back up your
And
claim.
my spouse is a stay-at-home parent who has given up work and education for 20 years.
Right.
Your lawyer will go over that with you if you have a lawyer, or you'll look at that and say, yeah, I don't know if maybe I can make such a strong argument about
Right.
that. It's also to prevent each other from having to just pester each other for information. Let's face it.
Get it out of the way, right?
Most people, when they're divorcing, just aren't interested in communicating.
Right.
And so the court says, we understand you're not really eager to say how much money you make, what kind of expenses you have, if they're embarrassing expenses and things like that you've hidden from your spouse or things like that. So they just say, everybody's got to lay all their cards out on the table to this extent in the form of initial disclosures and financial declarations.
So on the financial declaration.
One other thing on the
Oh, yeah.
financial, you have to not only identify it by giving the numbers,
Yeah.
but you also have to provide the supporting documentation.
Right.
And that would include
Photos of somebody
oh,
falling down drunk.
several years worth of tax returns,
Sure.
several years worth of pay stubs and credit card statements and bank statements and certificates of title to show what you own, and copies of receipts to show what kind of expenses you have. That's another thing I forgot to mention, is that you also include in your financial declaration a statement of your monthly living expenses.
You go over everything.
You go over everything. It's
gas,
really,
food, laundry, electrical,
yeah,
phone.
children's expenses,
Everything.
if everything you have, your monthly expenses and all that sort of, and if you can't provide receipts, you can provide estimates, because let's face it, sometimes you have an expense that you just don't keep receipts for,
Right.
at least you weren't in the habit. I would recommend, by the way, that you, as soon as you decide to get divorced, whether you filed or not,
Get in the
start
habit.
keeping track
Yeah.
of keep a receipt, ask for a receipt when you get gas, when you go out to eat and buy a hamburger for lunch or a sandwich or salad. Make sure that you say, I know how much I spend on laundry soap, I know how much I spend on dry cleaning, I know how much my cell phone and my regular phone.
And that's not to be annoying. It'll help you.
Yeah.
Because you need to come up with that
It's
stuff.
not to
anyway.
give you busy work, it's because that way when somebody challenges your claim to spend $240 a month on gas, you can say, well, you might think that sounds like a lot, but I've got 6 months of receipts that show that's exactly what I spend.
And one of the reasons we're making this video is because people often don't realize, they think, well, they may think, I'm not saying this is what everybody thinks, well, why can't those guys do that for me? That's why I'm paying an attorney a lot of money. These are things we can't get. We can't get your tax statements.
We don't
can't get
have your tax
bank
returns.
information.
We don't know how much gas you buy. We're not privy to your credit cards. You could give us that power and things like that, but even then, we would then have to go to each of these sources for this information and say, we're our client's lawyer, you need to help us, and here's proof of that. It's much better and much easier, much less expensive and time consuming for you to get it yourself. So, initial disclosures, financial declarations, parties have to exchange those early on in the case. And I'll just tell them about this right now. After, let's assume that if you're the petitioner, you have served your spouse has then filed an answer within 21 days of being served.
Right.
The petitioner has to provide initial disclosures and the financial declaration and all the supporting documents
Right.
within 14 days
So, okay.
of the answer being filed. And
Right.
then, if you're the respondent, you have, I don't know why it's so much longer,
Mhm.
you have 28 days in which to get
Right.
that done.
But that goes fast. That's part of why we're making this video.
In fact,
Goes
before we
too fast.
turned on the camera, we said maybe we shouldn't even tell anybody, because if we tell them somebody has 14 or
Then they
28
put it off
days,
to the last minute.
yeah, they'll get everything back to the
Human
attorney
nature.
on day 26.
Don't do that.
Right.
Right.
Because why?
Because no matter how good your attorney is, if you don't give them the initial disclosures, the financial declaration, the stuff that you have to have, the requirements to move forward, we can't do anything for you. I mean,
We don't know.
We're raring and tearing
And
ready
this
to go.
takes time.
We
This
can't do
takes
anything.
hours for us to prepare
Yeah.
to go over to make sure it's accurate. We have to add up numbers. We have to make sure everything jibes.
Right.
And if you don't give that to us, we simply will not be able to perform.
Yeah, we're not
And-
going to turn stuff in that we know is incorrect or
Or
not
incomplete.
factual or incomplete. Right.
That's right.
We're going to go over it and review it, but we can't get it to us to start that process.
Okay. And I'll ask you, because Brian often does a lot of the processing. He's the one that takes in the tax returns and the statements and the receipts and scans them in and uses them to prepare them in the PDFs that we ultimately exchange. How long does that take?
If you get it done right off the bat, a few hours,
Right. How long do you end up spending just continuing to bother the client?
Long time. Weeks.
Weeks and weeks. Now
And
remember,
then they'll still.
how many days
put it
do you
off.
have if you're the petitioner? You have
Right.
2 weeks.
Right.
Tops.
Yep.
We have lots of clients, through no fault of our own, that just don't get to it, and we understand why. It's no fun.
They're not sexy, but you have to get them done.
Yeah.
You just got to get them
Yeah.
done.
And so we wanted to tell you a little bit about, now that you understand what this is, if you're somebody that's watching this because you've just been informed by an attorney, hey, I need you to fill out your financial declaration and provide me with your initial disclosures, we want you to understand what we usually encounter and how frustrating it is for us, because we want to help you. We want you to win. We want you to do as well as possible. So I'm going to turn it over to you.
Okay.
Tell people a little bit about what typically happens from the time. So we have a new client, and we've told, like, thank you, you've signed the fee agreement.
Right.
What do we do next, and what usually happens? Not what's supposed to happen, but what's our experience. We've told you what you're supposed to do. Now, Brian, give them an idea of what happens, and we're not without feelings. We understand, but you're only hurting yourself.
Right.
With
We get it. People are busy. They're like, the divorce is the last thing you want to think about, although you can't stop thinking about it because you're so stressed out all the time about it. But what happens is we'll say, okay, we need these back, and we'll even set a time to follow up, maybe meet with you in person to do the review, and people they're either too afraid to fill it out wrong, and we get it, you don't want to fill it out wrong, waste your attorney's time, you're paying for your attorney. But at the same time, if it's not filled out at all, we can't correct the mistakes. We're like, okay, well, now we have even less time. Now it's even more important.
So what Brian's getting at is that we will give you those forms right at the beginning.
Right.
We don't want you to miss out on a single hour of time in which you have to respond. But what usually happens is we give that to you, and then, we shouldn't be disclosing this, but we will. We will not tell you have 14 days to respond.
Right.
We'll usually lie to you and tell you have 10 days to respond.
Because you need a buffer zone.
Because we need a buffer zone.
Right.
Because what happens is, if we tell you 10 days, when do we get it back from the client? Day 9.
Yeah, or 11.
Yeah,
I was
exactly.
so close.
Yeah, right.
Yeah.
And so what happens is, we understand, people just don't take us seriously. We don't really understand exactly why, we just know it happens. But we tell people, this is important, you've got to do this, we explain it. We don't want you to just assume that whatever we tell you to do is gospel. We do, hey, the rules say this is required, you can get in a lot of trouble if you don't. Here's 10, we need this back in 10 days.
And that's in the best case scenario. If we get hired late in the game,
right? If you hired us,
I've got to get an attorney now, right now.
Yeah.
Then we've got 5 days, and if you don't get it done in 5 days, well, now you can't submit it. Now, if they go to trial, how are you going to back up any of your arguments?
So you've got to do it, and if you don't, it's not only a matter of making it difficult, but we talked about your credibility suffers. Right. But on top of that, you also are sending a subtle message to your spouse at a time when you need to stand strong that I'm weak, I'm scared, even if you're not.
I don't really care.
Even if you're not weak, even if you're not scared, even if you do care, it can send the wrong message. And let's face it, at a time when you're getting divorced, your spouse and you are more than happy to ascribe every malicious motive to any innocent mistake. Don't make those mistakes needlessly. Now, you brought up something that we needed to talk about. We talked before we went on camera about initial disclosures that I thought was really important. What's one of the reasons we didn't really notice, but then we had some brave clients who were telling us, why would some people not provide us all the information they could have and should have on their initial disclosures?
Right, because they were worried that if they put someone down as, name, address, and subject matter, the subject matter is just a brief description of what they can bring to the table to prove your claim or whatever issue you've got going on in your divorce.
So they would say, I actually know 12 people that could be very helpful to my case, but don't
call number 11. Because
I won't even tell you who they are. I'll identify 3 people to you, but I actually could think of 12. Why do they do that?
Because they're worried that when you write it down, that means they have to go to the stand in trial. That's not the case.
That's not the case. Whoever you identified as a potential witness is not requiring you to call those people as witnesses. In fact, most cases do settle. So that person may never even be aware that he or she has been identified as a potential witness and may never get called. Now, along the same lines, if you happen to know of someone, and remember, you don't have to disclose people that will hurt your case. If you know someone that might be a good witness, but also might turn on you, don't identify that person. You don't have to. It's only people you think are helpful to your case, your claims, and your defenses. All right.
If they were identified, though, you don't have to call them to the stand, right? How could that bite you? Like, let's say, for example,
you didn't identify them because, frankly, you didn't want
they're credible enough.
You didn't want them to turn on you.
Sure. Okay.
And so you don't need to tell your ex about a potential witness against you. You
Right.
only have to talk about people that can help you.
Okay.
All right, let's lay out a typical scenario. We've been retained, we've given the client the forms, we've told them the deadline by which it is due.
Right.
We get it back. In the event that we do get it back on
Okay.
time, the financial declaration form is between 10 to 12 pages long, depending upon how much information is in it. So our client brings or emails us the financial declaration. What does it look like?
Usually it's, some of it's filled out.
How many pages?
Out of the 12?
Yes,
Well, I'd say 3 or 4 are informational, right?
he's lying. It's
Is
like
that
the first
true?
two.
Okay, the first 2, I'm
They
sorry.
fill out the first two. Now,
Right.
we know.
No, I meant the form itself.
We're being blunt with you here.
Yeah.
Why do you send us 2 out of 12
Right.
pages? You complete 2 of 12 pages. Why do you do that?
You're
You don't
scared,
believe
you
us.
No, you think it's not important.
You don't think that we
Yeah.
really need this information.
Right.
You think that it's busy work and you don't like it. It's embarrassing to look at how little you earn. It's embarrassing to, or how much you earn. It's embarrassing to have to show all of your debts,
How much you eat out,
including the
or-
debts for those embarrassing surgeries that you had and those prescriptions that you have. We understand it. You're laying your life bare. You don't want to talk about it. You don't want to make the effort.
Right.
And on top of that, you think we're just making this up. You think it's something that we want just so that we can have an easier time working on your case, but you don't really think we need it. You certainly don't think it's required. So you're testing us. And you know what? All is forgiven. But this is a test you will fail. When you send us the 2 pages,
It hurts the client the most.
it does, but Brian's going to tell you what happened. So, we lied to you about when it was due. We actually moved it up and gave you a shorter period of time for your own good. You either gave it to us on day 10 or day 11. What happens next? And you gave us 2 pages. So, Brian, what do you end up
So
having
now it's
to
up
do?
to us to cross all the T's, dot all the I's.
So tell them specifically, this is Brian's job.
Okay.
So Brian, what do? You get it, you see it,
Then
you go through it and you go, first 2 pages of the
missing this.
financial declaration,
Right.
the initial disclosures, if we got anything at all, aren't complete either.
Right.
All right, so what do you do? What do you
Then-
have to do for the client next?
I've got to keep hounding him for it, asking him for it.
Specifically, I mean,
Yeah.
what do you do?
I have to say, okay, this isn't filled out. We need this. We don't have that.
You send them an email?
Yeah, email, call, email, call. A lot.
So like 3 calls?
Sometimes 3 to 10.
4,
20,
5, 6, 20, yeah.
sometimes, right.
I mean, we just have to, because, and again,
Right.
it comes back to what Brian said. If we could do it, hell, it'd be easier for us to do it. We would do it, because frankly, we just
Excuse me.
can't keep, we don't know.
Right.
We don't know what your 2014 tax return said.
Right.
We don't know what you're getting paid. And even if you told us, we're not going to tell that to the court if we don't have some evidence to back it up.
W-2s.
Because the first thing that's going to happen is if we tell the court, trust us, he makes $3,500 a month. The
Yep.
spouse is going to say, well, do you have some evidence of that?
Right. Where's the taxes? Where's the W-2?
Yeah, where's the pay
check
stubs?
Right.
Right.
Yep.
Okay, so you've sent the emails, you've made the phone calls, and then what happens?
And then if we set a date to meet with them to do a review, they'll show up, and even though it sounds like they're really prepared most
Yeah.
times,
Hey, are you ready? We'll notify you a day or 2 in advance. Hey, now remember, tomorrow we're meeting. You got everything ready? Yeah, I've got everything ready. And what do they show up with?
nothing
3
filled out on-
pages
yeah.
fill out.
Yeah.
Filled out.
Yeah.
It's just, now, are we doing this to complain about clients? Yeah, a little. But the real purpose of this is because help us help you. We cannot do this by ourselves. It's not that we're lazy, and it's
Right.
not that we're giving you busy work. This is required. And so what happens eventually is we just keep bugging you. We keep telling you, it's like, look, you're going to get in trouble. Something's going to hit the fan. And then we get the letter from opposing counsel, and it's some shrill, strident letter about, it is vitally important that I get this information, and you have withheld it, and I'm going to seek sanctions from the court. And you did it to yourself. We don't
Sometimes
work
they
bad.
can get sanctions if you're
They
taking
can,
too
yeah.
long. If you're not following the civil rules.
It's not going to come back on us. We've papered it to death. Now, we didn't do that just to cover our own butts, but it does. Hey, client, we gave you the forms. We reminded you when they were due. We encouraged you to get them done. We offered our help. We scheduled an appointment. You showed up with 2 pages filled out. You didn't get them done. You've got to get them done. And once you've ripped off the Band-Aid, you're like, oh, that wasn't nearly as bad as I thought it would be.
Right.
It was bad. Hey, when you rip the Band-Aid off, there's a tiny little bit of pain.
Right.
But you've got to do it, and here are the benefits to you. Not only do you avoid having bad things happen to you, but when we get that information, we are then able to do a better job of representing you and talking about your income and expenses, your needs and abilities to pay and receive and that sort of a thing, so that we can make the best argument so you don't receive any less than you have coming to you and that you don't pay any more than you ought. So that's all I had to say on the subject.
Yeah.
Is there anything that you wanted to?
Just that, I think I've said this, but this is why we make these videos. We want you to understand what we're going through on our side so that you can feel confident about what we're telling you and you'll have your questions answered. That's what these videos are all about. That's why we have client schools.
Yep.
So that we can help you.
We appreciate you attending client school, and we hope to see you again.